how the buyer due diligence process works for co-ops. When you're buying a co-op, how does the due diligence process work? We'll break down what's involved and what the goals are. My name is John Moss, an attorney and partner at Moss & Moss LLP, a law firm started by my family in 1997. A large portion of our work is residential real estate transactions, and let's dig in. Unlike most other jurisdictions, real estate contracts in New York City do not have a rescission period or an attorney review period, meaning that once you sign the contract, generally speaking, you're legally bound to buy the property. But obviously, you, as the buyer, need to do your due diligence review. So the review actually happens before you sign the contract. To give a little context, in the course of the transaction, the broker will be handling the negotiation of the big-ticket items, such as the purchase price, the approximate closing date, whether the contract is contingent on the buyer getting their financing, and a few other details. Once the offer is accepted, the attorneys pick up the ball, and the seller's attorney issues the contract for the buyer's attorney to review. While the attorneys are reviewing and negotiating the details of the contract, the buyer's attorney is also reviewing the due diligence materials. The due diligence review for an apartment in a cooperative corporation consists of 4 basic elements: reading the past year or two's worth of minutes of the co-op board meetings, asking follow-up questions, or submitting a more extensive questionnaire to the managing agent based on the review of the minutes, looking over the financials of the building, and, lastly, glancing at the offering plan and the bylaws. I should note that the due diligence of newly constructed buildings consists primarily of reviewing the offering plan, but that's a different subject for another time. The co-op board meeting minutes generally describe how the co-op board runs the building and what they've been working on. The minutes typically describe what major capital improvements the building has undertaken to date and what they've considered starting on in the near future. The minutes also usually talk about how the board interacts with the shareholders, reporting on disputes and litigation, if any, as well as other requests or inquiries. There is some financial information in the minutes, but since we're also reviewing the financial statements, more on that in a minute, the financial information we really want to focus on is how often the board has increased the maintenance. Lastly, the minutes usually report on approvals or disapprovals of incoming purchase requests, sublet requests, and alteration applications. The reason I keep saying typically or usually is because the minutes for each board are somewhat idiosyncratic. Some minutes have a lot of information and details, some are very bare bones. However, even the style of the minutes can tell you a lot about the building. The purpose for looking at the minutes is threefold. Firstly, we want to know the condition of the building in general and the apartment specifically. Secondly, we want to know what major capital improvements are coming up so we can determine whether you as a buyer will need to make extra financial contributions to the building in addition to your monthly maintenance. Thirdly, because the co-op board has such a huge impact on how you use your apartment, we want to know if the board is super hands-off or incredibly nitpicky. For the record, boards are usually somewhere in between, but we want to make sure. Even if there isn't a lot of details in the minutes, it can still give us a sense of how they conduct themselves. The review of the board meeting minutes historically happened at the managing agent's office, and the minutes were closely guarded confidential documents that never left that office. With COVID and remote working, that may be changing, but it's an open question on how boards will handle things in the future. For now, it's probably safe to assume that your attorney will continue to review the minutes and then report back to you, rather than be able to provide you with the text of the minutes directly. I will say that one of the useful things about going to the managing agent's office was that I usually have a chance to ask the managing agent questions when I've finished reading the minutes. Those questions usually involve specifics about the condition of the apartment or the line that the apartment is in, like if there have been any leaks or any instances of bed bugs. Sometimes that leads to emailing follow-up questions to the managing agent. Another common solution is that the buyer's attorneys will submit written questionnaires to the managing agent. Sometimes the managing agents charge a fee to respond. However, in other instances, there isn't enough time for the managing agent to reply before the seller wants the signed contract back. While it's always preferable to get these answers in writing, this is discretionary and something you should talk about with your attorney. The financial statements of the building are the next item of review. These are audited by the co-op CPA and are freely disclosed by the building, and most attorneys will provide a copy to the buyers. The specific information we're looking for in the financials are: what are the cash reserves of the building? How much cash do they have on hand in their operating account? And whether the budget more or less balances. That is, does the monthly income generally cover the monthly expenses of the operating the building? There are obviously details and footnotes, and your attorney will need to explain the nuances of the financial statements to you. But generally, we want to know if the building has a reasonable amount of money on hand and a reasonable amount of money to pay for whatever capital improvements we found that they're undertaking when we reviewed the minutes. Is the board managing the co-op's money well? And are there any red flags, such as out of the ordinary line items or litigation costs? For my part, I've rarely seen a buyer not go forward with the transaction because of the financials, but it has happened. The real-world consequence of the financials not looking too great is that the buyer may have to expect regular monthly maintenance increases or a special assessment. By way of explanation, a special assessment is an extra charge that the shareholders pay to the corporation in addition to the monthly maintenance. It's usually paid on a monthly basis for some specific period of time, like 18 months or 3 years, and it's usually for a reasonable amount. To give context, as an example, a buyer might see a monthly maintenance for, let's say, 24 months in the amount of about $150 or $200 as against monthly maintenance charges of about $1,200 or $1,500. Moving on, if the building is recently built, your attorney may want to review the offering plan, which is a several hundred-page document that the developer gave to all the new buyers. Once the building is operating for a few years, the offering plan becomes less relevant. However, included in the offering plan, among other things, you can find the bylaws of the co-op corporation, and these are relevant to the ongoing operation board. Generally, though, the bylaws are pretty standard, so again, your attorney is really just looking for things that are out of the ordinary. Some clients ask if a property inspection, or specifically an engineer's inspection, is a required part or even just helpful for due diligence. Generally, in New York City, the answer is no. For a co-op, the co-op corporation itself is largely responsible for the system of the building, meaning the plumbing, electrical, and HVAC, and of course, the corporation is also responsible for making sure the building is structurally sound. Absent a specific point of inquiry, these are the things that a home inspection would generally look at. If you as a buyer want to pay for an inspection, you're welcome to, but it's not necessary and not usually done in New York City. To wrap up, in general, the larger the building the board manages, the more involved the board minutes will be and the more substantial the financials will be. If you're looking at a small co-op, on the other hand, you shouldn't necessarily expect the board to have millions of dollars in the bank. What we're really looking for here is to make sure, again, that there are no red flags, that there's nothing that is way outside the norm. For this, you need to have an experienced attorney who's done lots of transactions and knows what to look for. In my practice, I generally provide my report on the due diligence to my clients in person or by phone at the same time that we review the final version of the contract. That way we can go over in detail as much as the client wants to, and I can ensure that the buyers have an extensive opportunity to ask all the questions and to make doubly sure that they're fully informed about the property they're buying. Ultimately, the goal of the due diligence review is for the buyer to know what they are getting into and to feel comfortable with the purchase. If there ever comes a time when you're buying real estate and you don't feel like you know what's going on, that's the point when you need to call your attorney and start asking questions. How the due diligence... No, I just misspoke. Brilliant, John!